Mr. Jerry ZHANG has many years of experience in international intellectual property law, corporate, commercial, and dispute resolution, particularly in Chinese law and its application in cross-border investment and economic activities. In the area of dispute resolution, Mr. ZHANG has acted as counsel in prosecuting complaints, claims, or acting on the defense counterclaim in various foreign-related cases. As arbitrator, he has accepted many appointments as sole arbitrator, co-arbitrator, or presiding arbitrator, or panelist in handling international arbitration or domain name matters with CTAC or Hong Kong International Arbitration Center. And his topic today is long-term oriented methods for dispute resolutions in the Greater Bay Area. Mr. ZHANG, the floor is yours.
Okay, thank you very much. Thank you so much, Graham. Yeah, I'm grateful to the organizer for organizing this great webinar and for inviting me to speak today on the topic of current interest and great importance. My topic is long-term oriented methods for dispute resolution in the Greater Bay Area, GBA, right? Greater Bay Area. So, yesterday, one of my friends from US who lives in the Bay Area in San Francisco shared with me some of his recent experience of life and work in the US. A Bay Area is well known in the world about a good life work, right, in the US, like in those who have realized the American dream. So now we have the Greater Bay Area. And that is a wonderful thing for the countries around the Pacific Ocean, right? Okay, when I give myself this topic, I also wonder, what is the long-term oriented methods for dispute resolution? What is that? And I wonder and explore the topic, and then finally, I will give you my conclusion first, maybe, so that you can understand, and then thinking about the conclusions using both international and domestic practices according to the needs in the Greater Bay Area. So that's my conclusion. So long-term meaning that you would take a global and long-term view on dispute resolution. Now, the Greater Bay Area, as is very well known now in China, is certainly part of the plan of the government in China to support the further development of Hong Kong and Macau SAR. So you have 9 cities, like Zhaoqing, Guangzhou, Huizhou, Foshan, Dongguan, Zhongshan, Shenzhen, Jiangmen, Zhuhai, 9 cities selected around Hong Kong and Macau to be like a bigger pool in the future to have priority of economic development in the region to support the further growth and development of Hong Kong and Macau. So that's the basic idea. And certainly it's the mutual efforts, mutual agreement, the central government and the governments in the special administrative region, or SARs. So you then recall yourself that in the past, China's economic development really starts from the trial test of economic, special economic zone, right? Shenzhen was selected next to Hong Kong, which was early on a fisherman's port village there, but then now developed into a metropolitan city of world standard and competing with Hong Kong and other international cities. So this is something that you have to see with your open eyes. And if you haven't been to Shenzhen, I would advise that you go to there and then experience the development there in Shenzhen. So you will see how China's economic development has been successful in the past. Now, let's look at the construction industry. With the assistance from my student Adam Penn, who actually looked into the database of 2021, all the cases selected in the database alpha, etc. And then you will find that most of the cases are below the value of 500,000 RMB. So relatively, most of the cases are smaller cases, and there are larger cases over 1 million up to 5 million, and then further percentage further larger cases. But the most of the cases really require dispute resolution in a relatively cost-effective, cheap, quick methods of dispute resolution. So with that in mind, then we can further look at the current methods of dispute resolution and think about what are the better way of helping the needs of the parties. Because if it is relatively low, then you might take a fairly quick approach to resolve the dispute. Now, my slides were divided into basically 3 sections. Number 1 is to help you understand the whole structure of the Chinese legal system. It's about the legal framework. And then number 2, we will look at some cases in the construction field. And number 3 is some points of attention. So now, the Chinese legal system, it is a fundamental legal system that is governed under the rule of law. And we have to bear in mind that China is a state governed under the rule of law. And that's the basic concept that all human beings need to open your eyes, that China is really under the rule of law. And it has a structure, the pyramid structure. It's a pyramid structure with the constitution and the law, and then administrative regulations, and local legislation, and departmental rules. So, recently I saw a chat GPT finding comparison the U.S. and China, and that U.S. is under the rule of law and China is under some efficiency leadership. Now, that is only part of the finding. I think the legal structure in China is very sound and actually well in good operation. So that's why it supports the system to be operating relatively stable and relatively efficiently. We have certainly in the Constitution, of course, you see that there's a long preface about the history of China and about the policy like one country, two system, and the territorial part of China. And all of these are in the preface. Now, under the Constitution, there are laws, what we call law, right? 法律. That's not legislations with the word 法律, law there. And then further under, there are administrative regulations issued by the State Council. And then there are local legislation, which are basically what in English law termed as autonomic legislation or delegated legislation. These types, not necessarily the parliament, but they are authorized by the central government. And finally, you have the departmental rules, like all of the implementing rules for implementing the law of, for investment law, for example. There's not yet an implementing rule there. But these are the departmental rules from certain departments, for example, Ministry of Commerce, right? So we have a structure of these laws that are well in good operation. And then it's probably not so much widely disseminated in terms of knowledge, not necessarily propaganda, but disseminated in terms of knowledge that the public in the world are probably not made aware of this legal structure. For example, where this administrative procedural, these procedurals are very backbones of the system that supports dispute resolution. So we then have a question, in the Greater Bay Area, whether in the future, subject to party autonomy, the parties may choose the law, right? So they can choose Hong Kong law, they can choose Chinese law, mainland law, but whether they can choose both laws. And if they can choose both laws, then the judges and arbitrators will be very difficult to actually compare the laws and find out what is mutually sort of accepted in the laws to govern. And that's an interesting question to be raised in this type of seminar. And thank you for giving opportunities of raising these questions. Now, key legislation in the construction industry. Of course, we have the civil code, right? We have construction law, bidding law, Civil Procedure Law, Judicial Committee of the Supreme People's Court. That's what we call interpretation. So these are very important laws that lawyers and project managers need to understand. Then the civil code, we have general provisions, and then we have the typical contracts. Because we are a civil law country, and we have categorized the contract into different categories. Like construction contract is one category that it has enjoys a chapter there. So we read the provisions under the chapter that's important, and then we look at the construction law, and it's easy to find actually, once you have the English version. And then the methods of dispute resolution. Certainly, you have litigation, arbitration, mediation, adjudication, and neutralization. Now, many people will see that it's widely discussed litigation, arbitration, mediation, but adjudication, neutralization is less often discussed. And we might pay more attention to these methods in the future. So these are the methods that are available under the Chinese law now, and certainly, of course, under Hong Kong law as well, but there are different, as I understand, there are different features. Now, second part is case studies. I brought you 3 cases just to understand the situation. 3 cases in the area of construction industry. Case number 1 is a litigation case. It's started in 2003, and 莫志华深圳市东升工程有限公司与发生在东莞长富广场房地产开发公司有限公司建设工程合同，所以是一个建设工程合同。It's a construction contract involving real estate development and individual. So the case started in 2003 and then fought all the way to the Supreme People's Court until 2011. So 8 years are all involved from first instance, second instance in Chinese is appeal stage, 就是上诉 appeal stage. First instance 就是一审程序，然后 second instance 二审程序meaning appeal stage. And then retrial. And the retrial is a situation where if a party is still unsatisfied with the result of the appeal judgment, and if he thinks that the law is applied incorrectly, and if there are fundamental wrong made in the process, and then they can ask a leave of the president of the appeal court for further retrial, and then go to the retrial stage. So there's a retrial stage after the appeal stage, after the second instance, and that makes Chinese civil litigation to a very lengthy stage. And the ultimate solution, that invalid contract, the retrial court finally determines that this is an invalid contract, and losses that has been materialized, that has been fixtures, intended into fixtures, be assessed per as is basis. 根据现实情况来确定一个损失了，因为有些这个已经物化了的，就是你投资这个房地产开发，有些已经转成金钱已经转成了这个房地产了，对吧？这个物化了，那么这个就是按现实的这个现状来进行赔偿。As if the contract is valid, but could not be compensated more than a valid contract. So there's a very interesting rule out of this retrial. Now the idea of this case is to tell you that litigation can take as long as many years. And this case is like 8 years. 8 years, it's a long time, right? So that is the availability of the court system for you to spend 8 years to get the result of the justice, the final justice of the case. Now, people, particularly in the economic and trade area, people wanted to use arbitration, and I selected from actually CTAC published a book on a real estate case. It's a leasing arbitration on leased property, but construction done where the property is subject to fire protection. So there are fire protection corridors that is there, and then the parties still go ahead with the construction, and then that contract is declared invalid by CTAC arbitrators because it's a breach of mandatory safety requirement. So the contract declared invalid. Now it takes 1 year, as we all know that usually arbitration takes a shorter period of time, right? 1 year or 1 or 2 is roughly the normal course of the event for an arbitration case. So the second case is on arbitration, and the third case is on mediation. And it's a recent case involving the second instance, the appeal stage, where the one trial, the appeal judge was appointed to mediate, and then finally through the mediation process involved in the litigation process, in the appeal procedure, and finally a mediated settlement agreement was reached, and then parties happily go home. So in this case, one judge presided. It's a very recent case, in 2021, and it's started from Shenzhen Intermediate People's Court. And finally, a mediated statement was issued. So in this case, you can see that mediation is involved in the civil procedure and is used actually widely in practice, that the judges, acted as mediators to help the parties to resolve the dispute. And that is partly allowed and also part of the civil procedure. And actually it's encouraged from the point of view of harmony and peaceful resolution of dispute. From that point of view, the parties will be happy to have a final mediated settlement agreement, and then they can continue their business relations, etc. So this is a case that you can see that mediation is used in the appeal process in the case in the Greater Bay Area from Shenzhen, right? Now, the third part of my talk is really on some points of attention that for us to see and pay attention, because paying attention to certain things is important in life, right? Certain things are important and you have to pay attention. I will make it shorter, really, so you can see the final line. Okay. With the above discussions of case studies, you can see the litigation could take a long time if it goes all the way to retrial, right? Arbitration is most widely used based on one final decision. So arbitration ends with a final decision. It's a one-time process and ends with a final decision called arbitration award. And the arbitration award is recognized in law in China as legally effective and enforceable, and also internationally recognized as enforceable under the New York Convention, and provided that you comply with the New York Convention, right? And mediation is quick and can be used in both arbitration litigation in China. So mediation is a relatively flexible method of dispute resolution that can be used by the arbitrators, by the judges in the proceeding before them. So mediation is something, very quick solution idea, right? I wanted to have an early settlement. And then adjudication is used increasingly in construction projects, and we'll look at that in more detail later on. Neutralization is used to assist all the above. Now, neutralization is something that people may need to learn in the future from the Chinese civil process, civil law process. Here, neutralization has a function of neutralizing documents and evidences, and notarized evidences are recognized in law as truthful and effective. So it helps arbitrators and judges to resolve disputes by looking at the evidence. Once you have notarized evidence, basically you accept the truthfulness of these evidence. So notarization is a tool that construction projects managers really need to use in the future, because now in China there are altogether I think according to published information, altogether 2,947 notarial offices， 就是有2947吧。现在的情况就是有公证处吧。所以公证处呢 ，the notarial office, they have the function of notarize things and documents and evidence in the project, especially in construction project. If you have a development of houses and buildings, and then maybe there are property certificates that need to be notarized, or maybe there are design documents that have been transmitted to you through emails that you need to notarize in the dispute resolution process. So make use of notarization fully in the future, and that's helpful for your dispute resolution. Now, international arbitration, commercial arbitration certainly is widely known, and everybody getting familiar in that. In the commercial field, right, it's basically resolving dispute by way of impartial third-party court arbitrators. So arbitrators, are the third-person decision makers that resolve the dispute by issuing arbitral awards after hearing the parties. And international commercial arbitration, it's widely known in outside China, but in China, by way of rhetoric, we might be more often using the term economic trade. So that's why, like CTAC, China International Economic and Trade Arbitration Commission, this is really driven from the Chinese language perspective, because economic trade, 经济贸易, it's a full character based term, right? It's easier to get through to the minds of people in the hybrid structure of the socialist market economy. So economic and trade is more widely used than commercial. Commercial is two character based, 商事. So 商事争议呢, academically is widely used, but in practice, people use economic and trade as a terminology. And then unsatured model law, we all know that commercial is defined under the unsatured model law, and these are activities that, sorry, it's already very time sensitive discussion. So I will go forward further on the international. It's a question under the CISG about business places in different states. Now, CISG, it's the convention for international contracts for international sale of goods, right? So now CISG is already admitted as a law in Hong Kong, and the question is that in China is a state party to CISG, and whether contract dispute between Hong Kong and mainland Greater Bay Area parties, whether they will be fall into the international category or into some special category between the regions. And that's a question that we need to resolve in the future in terms of the central government legislation and the interpretation, mutually consented. Interregional arbitration, Hong Kong, whether Hong Kong preferred or otherwise, it's a party choice, and the parties may have a choice to choose Hong Kong law or both Hong Kong law or mainland law in order to resolve the dispute. This is an interesting case, Z versus A and others. It's a Hong Kong case 2015, first instance case. It involves a contract with an arbitration clause, arbitration in China, and this was settled in China. So the word in China is used. And then ICC, it's an ICC arbitration clause. ICC, somehow I wonder why ICC did not contact the Chinese National Committee under CCO. ICC appointed Australian well-known arbitrator to handle the dispute, who gave a decision that sitting in Hong Kong had jurisdiction over the case because Hong Kong is part of China. That's logically is right, and the case actually went to first instance, and then the judge also determined that the arbitrator had jurisdiction based on the clause in the contract, because by logic it is not incorrect that Hong Kong is a part of China, so the decision confirms the arbitrator had jurisdiction. This is a very good example that because of return of Hong Kong to the mainland because of one country system. And there will be new perspective that will be taken from specific actual cases. That an arbitrator sitting in Hong Kong thought clearly that certainly Hong Kong is part of China, right? But an arbitrator sitting in the mainland probably, will still think that China means mainland China. That these are the things that are changing in real life about the people's perspectives, and we need to bear in mind that we have to align with each other on these interpretations. And it's a better way to look at the ordinary way of interpretation in contract law, whether that confirms the jurisdiction or otherwise, to resolve the disputes. Otherwise, because if the dispute is not resolved by confirming the validity of the arbitration clause, then the parties may spend 80 years or further longer years, but find nothing and cannot enforce the arbitration award under the New York Convention or under the mutual arrangement between Hong Kong and the mainland. Now, this interestingly gives us a conceptual dimension about one country's two systems applicable to these regions, and we have to understand one country two system, meaning the two socialist system and capitalist system, right? So the capitalist system will kept intact after return Hong Kong to China. Now we have the most recent 20大报告, right? 20th Parties Congress that proposed 两个毫不动摇 two unshakables, meaning that it will be unshakable rule to protect the public ownership of the economy, and it is also unshakable rule to encourage, support, and lead the non-public sector of the economy. Non-public sector 就非公有经济, then basically the private sector of the economy, right? Because China is a hybrid of the economy. You cannot look at China from a distant point of view, either from North America or Europe. That China is truly under the orthodox theory of Marxism. Actually, the Marxism is already developed to a stage that is a reality that China is a hybrid economy with public ownership and with a large amount of private ownership. And that's why international investors like Apple, Microsoft, and other Googles, and they have a big interest in the market with the private economy investment, right? So, and protected by Chinese law. So we cannot use a very old eye look at new things here in China. Now, Chinese style modernization, it's something that most recently proposed from the last two sessions, right? The two sessions, National People's Congress and CPCCC. This concept is fairly, I think it's more fitting with the Chinese reality, more fitting than the words like a rising of power, rising of economy, resumption, etc. These words may have other meanings, but the Chinese modernization really catches what the country is doing. It means, first of all, it's a big population-based modernization. We are all sort of advancing forward modernization, right? So big population-based modernization. And secondly, is a common prosperity modernization. And thirdly, it's a material wealth plus spiritual civilization combined modernization. And the fourth one is human and nature harmony modernization. So like what we say is green waters and blue hills, are golds and silvers. These are looking at China. And then finally, I like most is peaceful modernization. Peaceful modernization that China is developing on peaceful principles principle, right? You know, we have 5 principles of foreign affairs, and we adhere to the peaceful evolution of the modernization. So that means that in the future, we're gradually using legal means and other peaceful means to resolve differences, conflicts, and disputes at the state level and also at the private level. And that's a good thing for China. Now, I have 2 or 3 more slides to go, and just to finish that, positive side of mutual interaction, common law system, civil law system. If you look at the case Pacolito versus Klockner, you will find that that case brings out the opportunity to present a case as a legal principle under the New York Convention. And actually, it's part of Chinese culture to hear both sides. So the Chinese to hear both sides. And that, from another angle, from the parties' perspective, it is the parties having the opportunity to present their case. But from the judge's point of view, we ought to hear both parties. And that has a very long history from Chinese history on Jianqing. And after this case involves an arbitration award from CTAC, which was rejected enforcement in Hong Kong. And then after the case, 1994, CTAC revised the arbitration rule to include expert witnesses, appraisals, etc., to be examined in the hearing. And that's a good development. So we can see mutually a positive development of the interaction of civil and common law system. Mediation, Singapore has the mediation convention signed in 2019, August 7th, and now it has 55 members of signing states, and 10 of them. And I really wish that China will take up steps internally to ratify this convention, because mediation is so important in the region, not only Greater Bay Area, but ASEAN and peaceful resolution. And we should, at the top level, the NPC and the National Standing Committee, we should take up this task immediately and get it approved as an important convention to align the international practice and to make new things happen. Now, good things that GBA has the mediation rules already issued last year, I think it's 16th of December last year, right? One mediator approached 30 days period. It's very short and neutral, impartial mediators. So these are good development. And adjudication, CTAC has its rules. It's similar to adjudication, but it's called Dispute Board Review in 2015. And I think we can probably change it to adjudication, because in Chinese, adjudication, 审裁或裁断, has a function of the decision maker giving a binding decision. In a DB review gives a determination, and in Chinese it's very difficult to translate. It translates into 决定, but it's not as formal as people would expect, 审裁 or 裁断, that gives a authoritative binding decision for the parties pending other agreement of the parties. And we can learn from the Hong Kong adjudication rules and also Malaysia adjudication practice. Malaysia had a law, construction industry payment and adjudication law. I understand that a friend will talk about that, and that will be an important thing to learn. The latest development for international institutional arbitration to consider is the case of Brentwood Industries versus 广东法安的这个案子，2015年 2015 This case basically involves a U.S. supplier and Chinese buyer, equipment provided, but Chinese did not pay for the equipment. So there's a dispute, and ICC appointed a very well-known arbitrator, sit in Guangzhou and give a decision, give an arbitral award, and requiring the Chinese party to pay. And then later on, U.S. party sought enforcement of the arbitration award before the Guangzhou court. And in this case, the Guangzhou court finally, after consulting with the Supreme People's Court, determined that this type of award would be treated as foreign-related award under Chinese law, just like CTAC award. That interpretation is another step further to open up the Chinese market to international institutional arbitration. So that's a good case for all of us to understand the new development. Now, concluding, looking at all of these conventions, New York Convention, Singapore Convention, and plus domestic law, and also the GBA regional agreement, right, between the government, the GBA basis of GBA, we should have confidence that the parties now have better choices to make in terms of choice of arbitration, mediation, or choice of law. So the party autonomy principle is very well, deeply accepted in Chinese law, and you don't need to be concerned with that. The concerned thing is very negative, but looking at the positive side, things are developing relatively in good, positive way forward, and you will be benefited if you come to the GBA. Now, with concluding remarks, long-term oriented is that Chinese market supported by party autonomy and contract freedom is there. And I say that we should use arbitration, mediation, adjudication as used in international practices. That is, we adopt international practices in the domestic field, and that will be supported by the law and the practices. And neutralization could be more often used because in the mediation, court-assisted mediation settlement is carved out. It's not part of the convention, but it really looks at the independent mediators, final confirmed settlement agreement. So in those situations, the mediator can sign, or the mediator can sign before a notarial office, so that the Yeah, I just finished that.
Okay, thank you, Mr. Zhang.
Thank you very much.
Please remain online anyway. Our on-site attendants, if you would like to raise a question to our speaker, please scan the QR code on the wall and ask your questions. And for the Zoom attendants, you may raise the questions through the Zoom chat room. I have one question already. Mr. Zhang, adjudication is increasingly used in PRC as mentioned in your presentation, which is relatively new in Hong Kong. Can you provide more statistics of adjudication in PRC? I think the question is it very common to use
adjudication?
Adjudication, yes.
Yeah. I returned from Hong Kong to Beijing in the year 2002, right? In 2004, I was involved in arbitration here in Beijing. But the basic facts and all the disputes were first handled by an adjudicator who was appointed by parties who was from Hong Kong. So you see that the market is so much widely open that Hong Kong adjudicator was involved 20-something years ago. I was very surprised to look at the adjudicator's decision, and it's a fairly lengthy dispute, and the adjudicator had very lengthy reports, and the arbitrators look at those. Rely on the adjudicator's findings in terms of facts. So adjudication was, I believe, is widely used with influence from Hong Kong and Macau in the international market. But CTAC also had the what we call dispute review rules. 就是那个评审的这个规则了. It's similar to adjudication, but use the English word determination and dispute reviewer. I would say that it actually works the same function as adjudicator, but there's a different name. So we might align with international practice using adjudication in Chinese 审裁或者裁断, because these are the characters that gives the people's mind that the decision maker, being reviewer, it's very, very soft. The implication of the words is very soft. It's relative given the fact that the disputing parties need to comply with the decision. These are the things that I can answer. Thank you.
Okay, there's no more questions for Mr. Zhang from the audience. So thank you, Mr. Zhang, and let us show our appreciation to our speakers here today. Thank you.